Hello, everybody out there. Good afternoon, evening, whatever, wherever you are, whenever you watch this. Hello to StreamYard, Kevin, John, Market Watcher, Donald, Renee, and whoever else joins us today. Greetings to everybody. Thanks for joining whenever you're joining. If at some point in time in the future you happen to see this and you have questions, please put them on comment. If I can answer them or if I can add something. Hi, Mark, by the way, and super cats. I like that one. Yeah, if I can answer your question, I will, but I do look at all the comments. You will note that I look at all the comments afterwards. So I look, and if I can answer something, I will. So I hope everybody's well out there. What I wanted to do, so yesterday I did a live stream during the day, at least my time, and after, and it was on the motion that was going to be heard coming up this week, tomorrow, and I was kind of describing what was going to happen, etc. And after I did that, I received because now I'm a party technically, so now I receive all the pleadings directly. Pleadings are all the filings that happen in the court. So after I got off the live stream, I got 3 oppositions to the motion that I was talking about. So I figured before it happens, I might as well kind of like let you guys know what the oppositions are, and I can take a stab. Also, pure speculation, by the way, as to what's going to happen. Of course, not legal advice, not financial advice, not even marital advice. I'm sorry for all you out there. But I figured I'd kind of summarize kind of what all the oppositions are briefly in some form of English, hopefully, and then kind of tell you what I think the court might do, and then go from there. So we'll do that way. Before I start all that exciting stuff, and I'm also going to talk about Alpine for 1 second, just to kind of clarify a point that people seem to miss. Some people seem to miss. Anyway, did you hear about the Spanish-speaking train thief? He had loco motives. You know, a thief broke into my house last night searching for money. I woke up and I started the search with him. What do you call a thief who keeps things they stole on public display? British. You'd have to have been traveled to England to understand that one. And last but not least, and probably the one we all can identify the most with, what's the difference between an amateur and a pro thief? An amateur thief says, "Give me all your money." And the pro thief says, "Sign here." Anyway, I'm sure we can all identify with that. So before I talked about the oppositions, I wanted to briefly talk about Alpine. So for those of you who don't know Alpine Securities, it's a business, ongoing business. It was a prime broker for GTII at some point in time, apparently per the DTCCC. I believe in that word. You cannot say the C enough, so you can keep on repeating the C forever, in my opinion. They had a concentrated short position, yada, yada, yada. But anyway, in the expedited expulsion proceeding, and the reason I'm bringing this up, because I literally just read somebody's article about this that they put out today, and they should have just called me, honestly. I can give a more accurate depiction of what has gone on and what has gone, certainly as to Alpine and GTII. I think I'm pretty comfortable with the procedural as it's gone on. But there was reference, because I raised it. So the Supreme Court denied the initial request of Alpine to take over and handle their case against FINRA based upon the expedited expulsion. And so they originally asked for a stay, and Justice Roberts said no. And then they asked that the Supreme Court intervene in the proceeding, which was a disciplinary proceeding, They hadn't been expelled yet, but asked them to intervene because FINRA was unconstitutional. The court, either yesterday or the day before, the court being the Supreme Court of the US, denied their cert. That just means they didn't accept the case. Now, some people think, and perhaps correctly, this is opinion, but some people think that just because, and the Supreme Court handles very few cases a year, maybe, under 100 plus or minus, very selective. The term ends in June, so we're just about at the end. We'll start in October in the fall. That's kind of how it goes. So they had requested the court to intervene, claiming that FINRA was unconstitutional, etc. That was pending. The court said no comment. They didn't comment any reason. And I'd said this before, just to clarify, just because they didn't accept the case doesn't mean they're making a determination of any sort on the issues. It could just be, if I were on the Supreme Court, maybe next week, if I were on the Supreme Court, the first thing I would look at, or one of the things, where are we? Have they been expelled? If not, why are you bothering me? Because the Supreme Court is very narrow in terms of the number of cases they're going to look at. I think, this case, as I said, was premature. There was no reason for the court to intervene because they hadn't been expelled yet. Maybe they'll be successful. What happens if in the expedited, their point was the expedited expulsion, the reason when they intervened, the reason why Alpine went to the Supreme Court was it was because of the expedited expulsion proceeding. Well, what happens if in the expedited expulsion proceeding they win? I mean, so what? So what's the harm? Anyway, so contrary to popular belief, I don't believe that the decision not to hear the case says that Alpine doesn't have a position with regard to FINRA. I just think it means that this case was not in a proper position for the Supreme Court to take it. Now, I had suggested, it's not the reason for this live stream, but I had suggested to Alpine's counsel, and I hate Alpine, obviously, but I'd like the SEC to go in and take over Alpine through receivership, of course. But I suggested that they abandon, in essence, their one that just got denied and go in on the other one where the FINRA just affirmed their expulsion, not the expedited expulsion. And now there is a appeal pending before the SEC as to the expulsion. The SEC can't give them a jury trial. According to a Supreme Court case of last year, Jarkessi, I think there's a good argument that there's a Seventh Amendment right to a jury trial and a bunch of other stuff. So I think that Alpine may revisit the Supreme Court and have a much better case procedurally to go after FINRA. There may be other cases that are better, that are in a better position now to move forward, but it's very possible that before the next term starts in the fall, that Alpine has sought intervention by the Supreme Court, and they might have a better position to do that. So that's a side issue. So to the extent you see anybody commenting beyond the fact, claiming that was a determination of the constitutionality, I don't believe it. I just don't believe it. And also, again, it was a very special and narrow procedure, the expedited expulsion proceeding. I just don't think it says anything. I think it just says that the case wasn't ripe for the Supreme Court at that time. So that's my 2 cents there, maybe 4 cents. So what do we have tomorrow? Tomorrow we have the hearing. The hearing basically is to enjoin. So the hearing I'm referring to, I shouldn't just say hearing, the hearing's in Las Vegas. The hearing is with regard to the receiver's objection to those, what the receiver characterized, I think, is illicit shares of dubious nature, of dubious consideration, something like that. And the hearing tomorrow is, because in the motion that was filed by the receiver's counsel, I think there was 87 names and various transactions that were identified. I think about 178 million and change of shares. That's what's before the court. Now, it's really what's before tomorrow appears to be is just the order to freeze the shares so they'll be frozen and they can't be transferred, sold, etc. That's what really seems to be before the court based upon my reading of the papers. However, there's an additional thing that's before the court, and that may not be decided tomorrow. And that issue is what happens to those disputed shares. If somebody goes after, for example, we'll just make up, this is all speculation and made up stuff. But let's say the receiver wants to claw back, that's the terminology that is used to get back shares. Claw back could be money, claw back, literally. If, for example, the receiver thinks that David Reichman, has 44 million of those illicit shares, just because he says it, is that sufficient, or does it have to be some kind of process beyond that to decide those kind of issues? And so part of the hearing tomorrow is, in essence, to decide what the procedure will be to challenge the designation made by the receiver that those shares were illicit, of dubious nature, etc. So that's kind of what's going on. And the receiver, and I haven't spoken to the receiver's counsel about this, but the receiver and receiver's counsel are operating off of the order that was instituted to make the receiver involved in this case in the first place, that gave the receiver all kinds of power. Part of those powers was to claw back money and shares. So it seems to be within his powers. It seems to be what was contemplated in the original receivership order, but I'm not the one who drafted it. I'm not the court. I'm not the counsel, so I don't know. And by the way, I should say this. So if you were in the original plaintiffs group, you should, and you have questions beyond, so I'm not advising you here. I'm just stating what I'm thinking, obviously. But if you have questions, you should contact Alex, who's the attorney for the plaintiffs group, if you haven't already. Hopefully whatever information I'm espousing here is accurate, but if you have a question about a plaintiff's question, you should speak to who your counsel is technically. So tomorrow, two purposes as I see it. One is a freeze of the shares, and two is kind of evaluate the process in which they're going to decide whether those shares are illicit and should be canceled or something else, or if they're not and the person should retain them. That's really kind of what the nature of the proceeding, at least it's scheduled for tomorrow. So 3 parties. I think that there was 87 parties that were involved. I don't know of those 87, per the receiver report and per the attachment to the receiver's report, there was like this big chart that had all these spider webs going on, and it showed who kind of was involved in this. It was literally a wide web. So of these 87 people that we discussed, I think I went through all the names. I don't know if, though, for example, I don't know if 50 of those, I'm just making this up, by the way, of course, like I make up a lot of stuff. I don't know if 50 of those, for example, are owned or controlled or advised by David Reichman, for example. So I don't know if, that's 87 different targets, or if that's one, and that one might have influence over a lot of them. I tend to think more that than there's 87, but whatever. In terms of oppositions to the motion itself, there was 3 filed. One was filed by Reichman. And when I say a name, I'm referring to their counsel, because I don't think Reichman actually prepared it. David Reichman, who, according to his paperwork, is 81 years old. Kathy Griffin and Justine Reichman. Justine Reichman is not a party to this proceeding. She's not a named defendant. She appeared at a deposition, I think, for .8. I spoke about that. .8 was some entity I think that was set up through the assistants or in connection with. GTII and David Reichman, and shares apparently went through .8. That's what apparently what the receiver suggested. So we have basically three oppositions, and those probably will be addressed tomorrow at the hearing. From Reichman, the opposition is basically one underlying claim is that the shares are legit. The shares he held are legit. The other thing is that he can't get, unfortunately, he doesn't have access to the records which would let him establish that the shares that are in dispute are valid and there was valid consideration. That's hard to, doesn't have the information. Now, the fact that he was a CEO, CFO, I think he was the chief accounting officer, he was involved with all the auditors, he had a tax practice before. The fact that he doesn't have the means or didn't have the means to keep track of his position, I find that hard to believe. That would be like, kind of if I had Tesla stock and somebody came up to me and said, could you prove that you have Tesla stock? And I said, oh, I can't. I'll have to contact Tesla and get them to do it. Seems ludicrous to me, that claim. And that is a claim that's made by Reichman's counsel, that they don't have access to the documents, he can't figure it out, blah, blah, blah. So that's one of it. And obviously I'm not a big fan of Reichman, nor do I believe what he says. And I think his interests are, this is my opinion only. I think he's guided by his own self-interest at this point in time, my view. Nothing that's happened has given me any other feeling. So one of them is basically I don't have access to documents, so I need access to the documents. Doesn't really contest the fact about the freeze. So I would say he probably consents to the freeze. He doesn't like the process afterwards. And part of that is so that this seems to be a claim that runs through all three of these, which suggests to me that perhaps these three groups did communicate with each other and their count. And I don't know this for a fact, but when I read the three oppositions, it appeared to me that there was a similar theme that ran through each, and it seemed to me that perhaps counsel for each kind of did discuss it with each other and decided to kind of do it jointly. There's also reference to third parties not joined, but those third parties didn't appear. So I don't know why somebody who's opposing is who's speaking on behalf of somebody who didn't oppose. That didn't make a lot of sense to me either. So the first objection is we don't have the materials, so I need them, even though Reichman doesn't object to the freeze, in essence. The second objection is the procedure itself. There's an objection that so as opposed to a normal case where if the plaintiff was suing Reichman, the plaintiff would have the burden of proof to win that case, just preponderance of the evidence, which just means just a little bit more than the other. Now, in this case, based upon the receiver's reports, seems pretty clear that the evidence is pretty damning, but their point is that this process kind of flips the burden because now they have the burden to show that the shares are proper without a trial, etc. So that's their contention. Interesting argument. I think the order of the receivership order is pretty broad, so that may negate a lot of their argument. The other part they say is, that they need discovery in order to proceed, which is interesting. I think discovery is fine. I wouldn't dispute discovery. I can't imagine though, and I've said this, and I don't know how he's going to do it. I don't know how the other defendants would do it. If they testify under penalty of perjury at a deposition, I think that's really dangerous for a lot of reasons. You can only imagine, if you're asked a question that might be determinative of an outcome, you might be compelled not to be exactly direct and accurate in your answers. And then if you're not, I gotta believe there's a lot of eyes watching. So they ask, each of them ask for discovery, and if I'm counsel, I say fine, and then I take their deposition, and then I put them under penalty of perjury, and we'll see where we go. Let's go for it, buddies. But they ask for discovery. I think that's fine. I mean, if I were, I think that's great. Let's go for it, and then let's depose all those people. Let them put them to the mat. The burden of proof is a issue I just mentioned. It's an interesting issue, but I think it's not. We're not talking about a final resolution on the merits. We're just talking about the shares, but it's an interesting issue. And then there's an issue about jurisdiction. Whether somebody who's not a party to the court, can they be held by the court? And then there's an issue. It's a Nevada company and the stock's issued by a Nevada company. So don't you submit to the jurisdiction of the court? I think it's already been determined in a way. But anyway, all these are raised. So how do I view that? It's interesting arguments. So what do I think's going to happen is really what the bottom line is. So I have no idea, but of course I will guess. So if I were to guess, I would say the judge will grant some form of freeze so that the shares can't be done. And then he will order the parties to meet and confer to generate an agreed upon procedure for handling any disputes as to those shares. And if there's no agreement, that the parties will submit their proposed process. There'll be a hearing, and the judge will decide which process should go forward. And I base that in part upon I've seen how this judge operates. Seems like to me that the freeze part, at least by Reichman, is not being contested. And it seems like all three oppositions are contesting the post-freeze procedure. And again, the way this judge seems, I think it's a fine method. It gets the parties to focus on the issues, agree, and if you don't agree, submit something, and I'll then make a decision as to what I want to do. That's kind of the way I would expect him to rule. So that's Reichman's basic opposition. The other opposition is followed by Kathy Griffin. Goes through basically the same issue: need access to documents, a lot of due process issues. We haven't had access to the documents. We haven't had discovery, burden of proof, pretty much the same thing. Also, there's an issue that runs through this is kind of interesting about the business judgment rule. And that rule is basically saying that if you're like a director and you make decisions and it's, based in any way on reality, generally you're given a lot of room to make mistakes without any liability. The only exception is fraud. And throughout these papers, I see all the parties kind of ignore the fraud. So interesting to me, but most of it is an argument about the process. Again, the post process, the switch of the burden of proof. There's also a claim and an issue about that injunctive relief. The freeze is being issued without compliance. And that there's not a reasonable likelihood of prevailing on the merits. I don't know what Ms. Griffin's counsel or Ms. Griffin is reading to believe that, but I disagree wholeheartedly in terms of, and if you read the receiver's reports, and they poo-poo the receiver's reports throughout there, honestly, I don't think, this is just my personal opinion and my experience. I've been involved in many cases where fraud was claimed and asserted. These facts are as bad as any facts I've ever seen. I mean, I bet you if I took these facts to Bernie Madoff, he'd say, I wouldn't do that stuff. Joke, of course, or an attempted joke. So the fact that there's an allegation of a business judgment rule, that all this was legit and everybody, acted in conformity with good faith, I think that's laughable. But most of it is a objection to the process. And I understand it's same kind of objection. That's why I think these council kind of discussed this before. Also, they want discovery lifted, and again, I agree. I think discovery should be lifted, and all the objecting parties should have their depositions taken under penalty of perjury. Let them go on the record. Let them, if they, let's hear their story under penalty of perjury. Let's see if it's as accurate. At the end, so Kathy Griffin's the most substantive of the oppositions. The Reichman opposition was pretty short. Kathy Griffin's is not super long because it's kind of like a preliminary step. She does indicate, I think it's kind of interesting. It's a declaration that's attached. She said she began working for GTI in mid 2009. Now, I don't know what, I'm just going to ask questions. I don't know what that means. What did GTII do which would constitute work? What would somebody do at GTII? And I don't even think GTI, I know in the current time, had no space. I know they bought furniture, but they had no space. So no revenue, no space. So what are you doing? So when you began working for GTI in 2009, what did you do? The next thing says, number 3, I received minimal salary compensation from late 2010 until 2023, when David Reichman paid me a salary for 2022. What's minimal salary compensation? And again, what did you do in that time period to justify a salary? And were there any concerns with regard to transactions that might have occurred during that time that might have been to the detriment of shareholders? And why were you paid in 2023 for 2022? What amount? What did you do? Next part, in apparent answer, part of my job was to review potential mergers and acquisitions to determine whether they were viable. What does that mean? What was her expertise to do that? We know nothing happened. So what was her value? What was her value to the company? As far as I know, no revenue, no mergers. This is what she's saying. I'm just reading from the declaration. I provided my opinion and research. And research on what? On multiple deals during my time at GTII. And David Reichman had the final say on whether to pursue and close a transaction. I don't know if that's true. I would think it would be some kind of vote as opposed to perhaps a dictatorial decision. But it seems like in this number 5 that Kathy Griffin is pointing the finger at David Reichman based upon her declaration. Because what she's saying is, I'm just going to read it back in 2 little short things. And this is why I wonder why people want to be subjected to depositions, because they'll be asked about this. So if she's deposed, she's going to be asked directly about that. Part of my job was to review potential mergers and acquisitions to determine whether they were viable. I provided my opinion and research on multiple deals during my time at GTI, and David Reichman had the final say on whether to pursue and close a transaction. So I think she's throwing it in the lap of Reichman. And if you recall, the receiver, I think, and this is not a direct quote, but this is kind of the feeling I got. I think it's more than the feeling. He thought that a lot of volatility in the stock price of GTII was during times where there were deals that came on the table and then they suddenly disappeared and somebody was blocking those deals. And I don't know if that's consistent with what she's saying here. But again, why would that be happening? And why would she be entitled to compensation if she was basically useless? Because she's saying that whatever she said was ignored anyway. So what was her value? Next, she says, instead of a salary for the majority of my time at GTII, I received shares as compensation. For what? Again, what did you do? What value? What was your expertise? During much of this time, it's not important. That's in my opinion, it's not important. That's the last part of the declaration. So that's her objection. Again, once discovery, I think in my opinion, let these people testify under penalty of perjury. Let's go for it if that's what they want to do. And if they don't want to have media, I was going to say this. Apparently they want to engage in mediation, but if based upon their position, I think that their mediation positions might be bullshit too. So maybe just going after them in litigation directly might be the better choice. That's just my personal opinion. The last objection is of non-party. She references a non-party because she's not a defendant yet named in this action. And I've had a discussion. I've had discussions where I made this suggestion. I thought there should have been a separate action filed in California, and that a lis pendens should have been recorded already against her property. Again, different attorneys could have different strategies, different opinions, whatever. That was my opinion. So she's filed an objection because she's one of some of her shares are named in that objection filed by the receiver. She basically objects on jurisdictional grounds, saying that there's no jurisdiction over her because she's not in the state and she's in California. Kind of the reason why I had suggested that they pursue her in California. And then same kind of objections about the needing discovery and having the right for a jury trial and not having waived it, and the like. And I, again, didn't really change anything. I would give her, if she wants to be sued in California, I encourage the receiver to take them up on their offer and do it. If that's what they want, they want to be sued in California, then I think the receiver should sue them in California and then take action against the property. It's my personal opinion. That's what the objection seems to be, besides the due process objection. So again, what I would expect to happen tomorrow, I don't know what's going to happen tomorrow because I'm not the judge, but kind of what I would guess is perhaps the freeze order is granted. The parties are ordered to meet, confer to decide on mutual in order as to how the process is going to go forward. If there's not agreement, that they submit separate orders. And I don't know, by the way, I don't know this to be true. I'm just making this order up as we go. And if there's not agreement, then the court will set a hearing, and then he'll look at what's been submitted and then generate some type of process. Of course, the court could say, none of this goes. I'm not going to freeze and get out of here. I just would be surprised based upon how it's been conducted to this point if he did that. So that's what I expect to happen. So just to summarize, we have the Alpine first. Alpine, I don't think that's a fatal blow and a final conclusion as to legitimacy of FINRA. As to the oppositions that were filed, the motion is going to be heard tomorrow. It's as to the freezing and the process in which those quote unquote illicit dubious shares will be evaluated. And that's the hearing. After the hearing, at some point in time, I'll report when I hear something. It's very possible there won't be a ruling tomorrow. The judge might take it under submission and rule later. I wouldn't expect it to be, late. Might be a few days. And sometimes what happens, he might issue a minute order, which is a decision that they make, but it's not a final order, and order the side that won to prepare a proposed order. That's something else that can be done. So there's a bunch of things that can happen. We will see. And I'll kind of gauge also what the judge's view is as to the process. But again, it looks like to me that the freeze part and, the keeping the status quo is, they might object to it, but that's less of a vigorous objection. Not having the right to discovery, the jury trial, etc., and the burden of proof seems to be the greater objection. It's an interesting argument, but again, we have a greater receivership order that might be involved. So I'll keep you all advised. I presume the hearing will go forward tomorrow. I'll let you know how it goes, and we'll keep you apprised. So everybody out there, be well, take care. Have a great evening, morning, nighttime, wherever you are, breakfast. and take care. Everybody, be well.